Hello, my name is Nick Cohenmeyer, and I'm a volunteer attorney with the San Diego Volunteer Lawyer Program's Unlawful Detainer Clinic. This video is for informational purposes only and is not intended as legal advice. You should consult with your attorney regarding your specific situation. In this video, I will be discussing Senate Bill 91, which was signed into effect by Governor Newsom on January 29, 2021. SB-91 extended and replaced AB 3088, the COVID-19 Tenant Relief Act of 2020. Notices. If you have a tenant who is continuing to pay 25% of the rent due to COVID-19 financial hardship, you should be aware that you must have served them with a new SB-91 notice no later than February 28, 2021. And you only have to provide this notice to a tenant who has not been paying the full amount of rent because they have claimed COVID-19 financial hardship. Remember that any notices that the landlord serves on the tenant demanding payment of COVID-19 rental debt have statutory language that must be complied with. SB-91 changes some of the statutory language in these required notices. Landlords who have tenants that owe rent for the period between March 1, 2020 and February 1, 2021 are required to send a notice no later than February 28, 2021 to these tenants, informing them of the extension in eviction protections under SB-91. So if you're watching this video now and you haven't already sent that notice, you should have. It's probably too late. Consult with an attorney whether you should do it now. Landlords are prohibited from serving a notice demanding payment of rent until the new SB-91 notice has been provided to the COVID-19 affected tenant. Now, SB-91 defines COVID-19 rental debt as unpaid rent or other unpaid financial obligations of a tenant that came due between March 1, 2020 and June 30, 2021. Now I want to talk about SB-91's rental assistance program. Perhaps the most important new feature of SB-91 is its state rental assistance program. The program administers federal relief dollars through state agencies such as the Department of Housing and Community Development, and under the COVID-19 Economic Relief Bill, $2.6 billion in federal funding was allocated to California for housing relief. Of this $2.6 billion, $1.5 billion is earmarked to be allocated directly to landlords and tenants through the state rental assistance program. The remaining $1.1 billion has been directed to large cities and counties with populations over 200,000. These entities can decide not to create their own programs and instead request that their state and federal funds be administered to the state program instead. So who qualifies for rental assistance? Now, in order to even be considered for rental assistance, 3 criteria must be met by each household. At least one individual in the household currently qualifies for unemployment benefits, or one individual in the household has experienced a COVID-19 related reduction in income and or an increase in expenses, and 2, at least one person in the household must demonstrate a risk of homelessness or housing instability, such as through a past due rent or eviction notice, and 3, household income must be less than or equal to 80% of AMI, area median income, as determined by the U.S. Department of Housing and Urban Development. Now, just because the household may satisfy the above 3 elements for rental assistance eligibility does not mean the household will actually receive the funds. Because even with $2.6 billion in state relief funds that California is getting, there's not enough money to cover the entire amount of California's collective residential rental debt. So these limited funds will be prioritized. Next, I will talk about the priority in which these funds will be allocated. So how will the funds be prioritized? Well, the first priority will be to households with either income less than or equal to 50% of AMI, or that include an individual who has been unemployed for 90 days prior to application. The second priority will be to communities disproportionately affected by COVID, as determined by the department I mentioned earlier. And the third priority will be for all other eligible households with a household median income less than 80% of AMI, area median income. Household income will either be measured as total calendar year income for 2020 or household monthly income at the time of application. In the latter case, income eligibility must be reassessed every 3 months. So how much financial relief can an applicant receive? Landlords with eligible tenants, such as those making less than 80% AMI, can qualify for immediate rental relief in an amount of up to 80% of the rental payments that the tenants missed between April 1, 2020 to March 31, 2021. For example, the tenant's household was not paid the monthly $1,000 rent since April 1, 2020 for an $11,000 payment in arrears. The most relief the landlord could receive is $8,800. And if the landlord receives this money, it would be considered payment in full for the arrearage to that point, so the landlord would be prohibited from pursuing payment for the other 20% that is currently in default. Who can apply for assistance? Landlords can apply to assistance on the tenant's behalf. Tenants can also apply directly for assistance. Proof of income eligibility may be required when applying, such as verification that the tenant's combined household income is 80% or less of AMI. So what happens if the landlord doesn't want to participate in the state rental assistance program? The landlord is not required to participate in the state rental assistance program, or SRAP as I call it. However, if you don't want to participate as a landlord, then you must understand that a judge at small claims could reduce the amount of damages awarded to the landlord, and also under regular civil trial. If you wish to avoid participation in the SRAP, State Rental Assistance Program, as a landlord, because maybe you think you don't want to forgo a percentage of what the tenant owes you through the mandatory compromise, then you might still be unable to collect the entire amount owed at trial, because your judge might reduce the total amount of damages awarded to what the landlord likely could have received if the landlord utilized the rental assistance programs that were available to the landlord at that time. So in essence, by not participating in the rental assistance program, the landlord may end up being awarded a maximum of 80% anyways. So there'd be no benefit to initiating that court action. You're really better off just compromising. Now, if the landlord refuses to participate in the state rental assistance program, the tenant cannot be evicted for non-payment of rent, as long as the tenant pays 25% of the rent that is outstanding on or before June 30th, 2021. Now, if the landlord refuses the 80% reimbursement for the past due rent from the state rental assistance program, a qualified tenant can apply for funding directly and potentially receive 25% of the past due rent. These funds can be used for future rents, but are limited to 25% of the rent due. And first priority will be for distribution of funds for rent that is already due, with a second priority to unaccrued future rent. Now, pre-existing state law prohibiting discrimination on the basis of source of income may prohibit a landlord from refusing to accept payments under the state rental assistance program. Now, there are discussions in Sacramento centered around the state providing additional funding to Californians who may not receive enough rental support, or those who are in need of support but are otherwise ineligible to receive it under the current program. When is the state rental assistance program, again, as I abbreviate it, SRAP, scheduled to begin and end? The earliest the SRAP will start providing rental assistance funds will be March 2021. According to the projected availability of funds, the program is expected to conclude on December 31st, 2021. All right, so now I'm going to talk about the obligation of the landlord to seek governmental assistance before evicting tenants in arrears. Under SB-91, until July 1st, 2027, that's right, 2027, a landlord seeking to collect COVID-19 rental debt must attach documentation to the complaint attesting that the plaintiff, landlord, made a good faith effort to do the following. 1. Investigate whether governmental rental assistance was available to the tenant. 2. Seek available governmental assistance for the tenant. And 3. Cooperate with the tenant's efforts, if any, to obtain rental assistance from any governmental entity or other third party offering rental assistance. Now, if the court determines that the landlord refused to obtain state rental assistance as provided by SB-91, where the tenant would have met the eligibility requirements and funding was available, SB-91 authorizes a court to reduce the amount of damages awarded as payment for any COVID-19 rental debt being sought. As you may already know from existing law, in an unlawful detainer action, if the plaintiff receives a favorable verdict by the court, then the court's judgment will be entered for possession of the premises, which is enforceable by a writ of possession of real property. Now remember, the court may also award damages to the plaintiff where the plaintiff properly demonstrates damages arising from the unpaid rent the tenant owed to the plaintiff. It's these damages that the court can reduce under SB-91 if the plaintiff does not attach the appropriate documentation to the complaint as mentioned earlier. Furthermore, before any entry of judgment in the plaintiff's favor can be entered for reimbursement of rental obligations arising between April 1st, 2020 and June 30th, 2021, the plaintiff must verify under the penalty of perjury that the plaintiff had made a good faith effort to utilize applicable existing rental relief programs for which the tenant met the eligibility requirements and funding was available. Now I'm going to talk about punitive damages against the landlord for intentional interruptions of tenants' utilities. SB-91 prohibits landlords from attempting to interrupt or terminate utilities to their tenants with the intention of causing a constructive eviction of the tenant. The penalties for violation range between $1,000 and $2,500 if the tenant has provided a declaration of COVID-19 financial distress that complies with the California Code of Civil Procedure, which is section 1179.03. SB-91 extends this prohibition against landlords along with the punitive damages for violations until July 1st, 2021. Now I'm going to talk about restrictions on the use of COVID-19 rental debt. SB-91 continues the prohibition against housing providers, tenant screening companies, or any other entity that evaluates tenants on behalf of a housing provider from using a tenant's COVID-19 arrearage as a negative factor for the purpose of evaluating that tenant's housing application, or using a tenant's COVID-19 related financial arrearage as a basis for refusing to rent a dwelling unit to an otherwise qualified prospective tenant. Now I'm going to talk about restrictions on assignment of COVID-19 rental debt. Under SB-91, a tenant's unpaid COVID-19 rental debt cannot be sold or assigned if the rental debt was incurred between March 1st, 2020 and June 30th, 2021. This protection lasts until July 1st, 2021. And if that wasn't enough protection, SB-91 also prohibits a person or entity from selling or assigning COVID-19 rental debt that arose between March 1st, 2020 and June 30th, 2021. Any person who would have qualified for rental assistance funding if that person's household income is at or below 80% of the median income for their area. Now I'm going to talk about using an ulterior motive to go after a tenant in COVID-19 related arrears. Currently, a landlord who has a tenant who has accumulated COVID-19 rental debt is prohibited from bringing an action for unlawful detainer against that tenant for something other than non-payment of COVID-19 rental debt in retaliation for non-payment. SB-91 extends this prohibition to July 1st, 2021. Now I'm going to talk about late fees and new fees. Currently, landlords are prohibited from attempting to collect late fees from a tenant for the late payment of COVID-19 rental debt, or increasing fees charged to a tenant, or charging the tenant fees for services that were previously provided by the landlord to the tenant without charge. SB-91 extends these protections to July 1st, 2021. Now I'm going to talk about protection for landlords and other homeowners. So during the effective time period of SB-91, which has just been extended until September 1st, 2021, for the purposes of mortgage forbearances, if a mortgage servicer denies a borrower's request for forbearance, the mortgage servicer must provide a specific notice to the borrower that explains why the forbearance was not granted if certain conditions are met. SB-91 extends the effective period of this policy until September 1st, 2021. Now I'm going to talk about protection from punitive damages for landlords who temporarily reduce or make unavailable a service or amenity in order to comply with federal, state, or local public health orders. So, under small claims court in California, small claims have had their jurisdictional limits waived for the recovery of COVID-19 rental debt. This means that the normal $10,000 statutory jurisdictional limit is expanded with no statutory prescribed limits until July 1st, 2025 under SB-91. SB-91 postpones the commencement date of any action to recover COVID-19 rental debt to August 1st, 2021. SB-91 amended the Civil Code to expire on July 1st, 2021 for these purposes. Now I'm going to talk about attorney's fees. California courts are limited from awarding attorney's fees in civil trials that exceed specified amounts depending on whether the matter is contested or uncontested in any action to recover COVID-19 rental debt until July 1st, 2025. Now I'm going to talk about limited access to case records. So currently for unlawful detainer actions, the court clerk shall only authorize access to limited case records to certain people under the following circumstances. By order of the court, if judgment is entered for the plaintiff after trial more than 60 days after filing the complaint, 60 days after the complaint has been filed if a plaintiff prevails in the action within 60 days of filing the complaint. However, the provisions allowing access to court records to any person do not apply if the plaintiff filed the action for default of rent between March 4th, 2020 and January 31st, 2021. SB-91 extends the limitation on the access to court records to July 1st, 2021. And if you want to see the full list of which individuals are authorized to have access to limited civil case records, check out Civil Code. Look up California Code of Civil Procedure section 1161.2. Now I'm going to talk about procedural requirements and limitations on evictions for non-payment of rent due to COVID-19 rental debt. So remember that the prior COVID-19 Tenant Relief Act of 2020, which we were commonly referred to as the CTRA, established certain requirements and limitations on evictions for non-payment of rent due to COVID-19 rental debt. One of these limitations was the protection of the tenant against being deemed in default regarding rental debt so long as the tenant delivered a specific declaration of COVID-19 financial distress to the landlord. In the definition of COVID-19 rental debt, under SB-91, COVID-19 rental debt is now defined as unpaid rent or other unpaid financial obligations of a tenant that came due between March 1st, 2020 and June 30th, 2021. Now I want to talk about security deposits. Under SB-91, any COVID-19 rental debt, which again is unpaid rent or other unpaid financial obligations of a tenant that comes due between March 1st, 2020 and June 30th, 2021, has certain restrictions on how the landlord can apply it. Unless the landlord agrees in writing to allow the landlord to apply the tenant's security deposit or next month's rental payment towards the tenant's COVID-19 rental debt, the landlord is prohibited from automatically applying a tenant's security deposit to satisfy COVID-19 rental debt or applying a tenant's monthly rent payment to any COVID-19 rental debt other than the upcoming month's rent. Now I want to talk about protection from landlord retaliation. If the landlord retaliates against the tenant because of the exercise by the tenant of the tenant's rights under the CTRA, or because of the tenant's complaint to an appropriate agency as to the habitability of a dwelling, the landlord may not recover possession of the dwelling in any action or proceeding, nor cause the tenant to quit involuntarily, which would be in a constructive eviction, nor increase the rent, nor decrease any services within 180 days of the latest instance of the following: tenant's complaint of a bed bug infestation, a complaint to an appropriate agency regarding the condition relating to the habitability of the dwelling for which the landlord has received prior notice, the date of an inspection or issuance of a citation resulting from a complaint by the tenant for which the landlord did not have notice, after the filing of appropriate documents, commencing a judicial or arbitration proceeding involving the issue of habitability, an entry of judgment, or the signing of an arbitration award where the issue of habitability was determined in the tenant's factor. A tenant cannot invoke any of these protections from retaliation more than once in any 12-month period, and a tenant cannot waive any of these protections. In addition, a landlord is prohibited from reporting or threatening to report the tenant or individuals known by the landlord to be associated with the tenant to immigration authorities. Any landlord or landlord's agent who violates the provisions of this section, which is California Civil Code section 1942.5, shall be liable to the tenant in a civil action for all of the following: actual damages sustained by the tenant, punitive damages in an amount not less than $100 and not more than $2,000 for each retaliatory act where a landlord or landlord's agent has been found guilty of fraud, oppression, or malice with respect to that act, and any act or action brought for damages for an eviction as retaliation for unpaid debt. The court shall award reasonable attorney's fees to the prevailing party if either party requests attorney's fees upon initiation of the action. Now, these remedies are in addition to any other remedies imposed by statutory or case law. Now, Section 1942.5 of the California Civil Code shall remain in effect until July 1st, 2021, which is the relevant section here. Now I'm going to talk about just cause. Under California's AB 1482, which was further expanded under last year's CTRA, California requires an eviction to be for a clearly stated reason, either an at-fault just cause or a no-fault just cause. A landlord cannot file an unlawful detainer action without just cause. SB-91 extends California's just cause requirements until July 1st, 2021. And for a list of authorized just causes, see the text of AB 1482. So tenants must pay 25% of rent to avoid eviction. Until June 30th, 2021, tenants will continue to qualify for protection under the bill from eviction as long as they submit a declaration of COVID-19 financial distress to the landlord within 15 court days of receipt, which does not include weekends and judicial holidays, and pay 25% of the total rent that is due for each month for which they are claiming COVID-19 hardship. And if they are deemed high-income tenants, they must also submit the necessary documentation. And there are two methods to comply. The first method is to pay 25% of the total rent that's due each month. The second method is to wait and pay a lump sum payment of 25% of all outstanding rent that accrued during the COVID-19 rental period for the months between September 2020 and June 30th, 2021, no later than July 1st, 2021. Now, in the meantime, it's recommended that the tenant continue to provide a COVID-19 hardship declaration for each month they are unable to pay the full amount of rent due. And if they're a high-income earner, as I mentioned before, they may also have to provide specific income verification documentation if asked to do so by the landlord. So as long as the tenant complies with one of these two methods, the tenant cannot be evicted for failure to pay the remaining 75% of rent. The remaining 75% of the rent will still be owed to the landlord and due by July of 2025 at the latest. It's up to the landlord to exercise a good faith effort to take advantage of any federal or state programs that will offset the tenant's debt. The landlord may accept an offer in compromise, but is not obligated to. So how can landlords pursue unpaid rent? Well, we could do another video on all the rent assistance that's part of the bill, but since it doesn't start till March, I'm not going to get into that right now. But it's important to remember that the tenant has two options if they're claiming COVID-19 financial hardship. They can pay the lump sum payment no later than July 1st, 2021, or they can pay 25% as they go, and then they have until 2025 to pay the full amount of rent. So I hope this has been helpful. It's been a lot of information. I know I speak quickly. If I speak too quickly, let me know, but I'm trying to save your time. So I appreciate you taking the time to share it with me as we learn together this very complex change in California landlord-tenant law. This combined with the COVID-19 Tenant Relief Act of last year, 2020, as well as AB 1482 before that. It's been very difficult for even attorneys to keep up with this. And again, I have to repeat that this is not legal advice. It's for information only. I am an attorney, but I am not your attorney. For information about the specifics to your case, you must hire a competent attorney. So I hope this has been helpful. Thank you.